again. Let's bring in Wayne. Wonderful Wayne. Here he is. Wayne Layton, everybody. How are you, Wayne?
I'm very well, Sonia. How are you?
Great to have you with us, Wayne. Really appreciate it. You are, of course, what we're calling around here now, the people's champion, Wayne Layton. And as I explained, you were with us recently, and you have proven in court the illegality of council tax enforcement agents. You've done sterling work there. And the last time that you were with us, you were preparing to go into court, weren't you, for a case management conference? That was in May. What happened?
Right. Well, that's a very interesting question. So the government, they've pleaded as their defence for these private bailiffs going into people's houses, paragraph 14 of Schedule 12, the Tribunals Court Enforcement Act. And I rebutted that by showing that a prerequisite requirement under common law is consent. If there's not consent, they can't use paragraph 14 to come into people's houses. Now they're trying to remove that requirement of consent by lying to people. And then when I showed that that was a requirement, they've now tried to change their defense. And this is the big problem, because in any sort of trial, if you want to change your defense, you've got two requirements you've got to meet. First, you've got to make an application under the Civil Procedure Rules.
Correct.
Part 17. And that's not just a flimsy, informal thing where you send an email. You've got to make an application, you've got to sign it, and you've got to pay a fee. And the second thing is you've got to have a good reason for it. You can't just wake up one morning and think, right, I'm not happy with that defence, I think I'll change it now. So you've got to do both of them. And the Court of Appeal made it clear that if you change it, you've got to have really good reason. Especially the longer the case goes on, the more stronger reasons you need, right? So they now want to change their defence, and they haven't made an application, right? And they haven't got any good reason. What they tried doing, which was very sly, is in a case management, you have what's called directions, and the court put directions in an order. They asked for the court to put in a direction for me to prove that they can't use force to come into people's houses. And they were relying on a different piece of legislation, right? Now, I rebutted that because that piece of legislation only applies to criminal fines. You can't use that for enforcement of council tax, right? Now, the High Court, they adjourned the hearing, so it never went ahead, right? And in that order, when they adjourned it, right, he's now given the High Court judge. I won't say the name at the moment, but it was a very perverse order, and I've applied to recuse himself. A recusal means that they step aside from the case. Yeah. And I've also applied to set aside that order because it's perverse. He gives them a window opportunity to change their defence, right? Now, the High Court do have a discretion to allow a defence to be changed, but only if an application has been made and only if there's good reason, right? And neither of these two apply. So he's giving them an unfair advantage to change their defence, right? So they on the order, it said until the 5th of June, 4 p.m. Now, as of today, they haven't changed it.
This is the Ministry of Justice you're talking about. If they can't get it right, who the heck can?
Well, this is the thing. I can't see them making any more submissions by tomorrow because I've already rebutted their new tried defence of using force to go into people's houses. That because it only applies in criminal jurisdiction for fines. So I can't see, unless they pull a bunny out of the hat. I don't see what else they can use because I've rebutted paragraph 14 and I've rebutted the criminal legislation. So, but again, I've applied to put his order aside. So it's going to be very interesting how that progresses. So, but I also want to tell people a very useful tip because currently these private bailiffs are lying to people when they ask to see their authority, right? What they say. It's a sleight of hand is they say when I won in 2023, right? The reason why I won is because they gave me a wrong letter. It was like said it was worded wrong. It was like a clerical error, a typo. Yeah, that's what they're telling members of the public. That was all it was about. It was just a wrong letter, clerical error, typo. Yeah. So just so I can tell the public, this is a complete deceitful tactic. Yeah. That first of all, there's three things there. In their defence, they formally pleaded in the Part 15 Civil Procedure Rule that they get their power from the council to enter people's premises. So it wasn't a case of a wrong letter or a typo or a clerical error. No. They formally pleaded it in their defence.
Right.
Second of all, Sarah Brown, who was a manager of Bristow and Sutter, took the stand and gave a testimony to say they get their power from the council. So it wasn't a clerical error. It wasn't a typo. It wasn't a wrong letter. She said that under testimony. And to make matters worse, the head of City of York Council, Paul Sanderson, also testified under oath that he himself had the power to authorise bailiffs to go into people's houses. And the best part of it, when I cross-examined him, right, I absolutely interrogated and understand that their barrister, Mr. Fender, stood up at the end and said he has no power. And I nearly fell off my chair because for 18 months they'd been pleading it. Sarah Brown took the stand and testified it. Mr. Sanderson took the stand and testified it. And then after cross-examination, the barrister held hands up and said, no, they don't have any power. So
you're embarrassing the system. That's the thing. You are literally humiliating the system because you're literally using the law. I mean, that's what you're doing. You're using the law, and they're having to lie to get out of this. This is outrageous, actually. And what is the situation?
It is. Regarding... And so this is a lie I want to tell people about. If they're telling you that my case was a clerical error or it was a typo or if it was a wrong letter, that's a lie. It's a complete deception. They pleaded their authority came from the council, and I proved the council had no authority. And so they're now lying people because they don't have any under authority. And now they're trying to use paragraph 14. That's another thing they'll try and say. They'll say that was a clerical error. Actually, the power comes from paragraph 14. And I've now just proven the Ministry of Justice that they can't use paragraph 14. So there's nothing left for them. Like I say, they've tried to use criminal jurisdiction, and now that's falling flat on its face. So...
what about the paperwork? So there's an issue with the paperwork regarding this, right? Because obviously now there's no paperwork; it's just verbal orders.
Yeah, verbal orders.
There's the issue with the council essentially appearing to fake on behalf of the court. What is going on there?
Well, yeah. So this is how I've submitted fraudulent documents to the council, and just to dispel any, because we get a lot of trolls and shills online who try and discredit me, and so just for you guys, yeah. If you go to the Ministry of Justice file, pages 275 to 285, you will see them fraudulent documents, and you'll see that I've submitted these as fraud. So this isn't an opinion. I've submitted this as fact. Right. And how I came across these fraudulent documents was by helping a vulnerable person. Right. So she had enforcement agents come to her house. Right. And they came in with no authority. And then, after a little bit after that, she got another summons for a liability order. So I went with her to the magistrate's court. Obviously, I couldn't speak. I was a Mackenzie friend. And I submitted an abusive process application saying that the council are abusing the process by going in vulnerable people's houses. And the magistrate, well, it was a district judge, he wouldn't read a defence. All he wanted to know was two questions. Have you paid your council tax? And do you live in the property? He wouldn't listen to anything else. That's all he wanted to know. Those two questions, right? And because I couldn't speak to the magistrate, I asked the clerk to refer the bench to the defence that I wrote for her. And he wasn't happy with that, so he asked me to leave. So I had to leave. They made the liability order verbally, right? And so at least the council didn't care. They weren't listening to it. So what I did was, because the magistrates did that and the council did it, I went after the enforcement agents on her behalf.
Right.
Sued them. Then they offered a £6,000 out of court settlement, right? On the condition that we don't tell anyone, keep it all secret.
And
right?
Can I just say, I've absolutely seen that documentation. That is absolutely the truth of what took place. Because some people will say, oh, that's not really what happened. That's exactly what happened. They offered $6,000 to buy your silence. And how did you respond to that?
Well, decision wasn't for me, because when I help people, for me, it's not about my benefit. It's about the welfare of the person I'm helping. So I said to her, it's up to you. And she's on disability benefits, so that's a lot of money. I thought she was going to take it. But yeah. She was like, I'm not being silenced. Wow. So she was like, no, I'm not agreeing to the conditions. I couldn't believe it. I was shocked. But I said, I'll support you either way. So she rejected it. Right. But this is how I found out the fraudulent documents. So she's rejected that. Now, what the council did, which is malicious, was because I'd effectively stopped these agents, and they were wanting to pay £6,000. They sent in another type of agency, another private company to go into a vulnerable house. And not only that, they started taking money out of the benefits. So they did attachment to benefits and sent in 2 different bailiffs. Now, I went back to the Magistrates Court because I'd made abuse of post application. I said, look, this is your fault. You granted the orders. That's given this council to do this. And I showed them everything. I said, look, one of the enforcement agents is screaming to settle out of court for $6,000. There's another one they're sending in, and they're taking money out of benefits. So this is your fault, right? So I sent that across, and they said, "Oh, we'll get back to you." Because normally, when you ask the magistrates for information, that go speak to the council, it's council matter. That's all they brush you off. But because there was an abusive process application, and I could prove the abuse, and it was because of them, they had to liaise with me to resolve the applicant. Now, what's interesting is I then challenged the council because I asked them for the costs, because they were charging her for their costs as well. So I wanted to know how they'd incur their costs, and I wanted a copy of any paperwork from the liability orders. What they sent across to me, right, was very suspicious. Very suspicious. They sent like copies of liability orders and this breakdown of costs. Now, in 2003, the physical paperwork of liability orders were removed. So there shouldn't be anything with like a court crest and a signature of a Justice of the Peace, because this was all removed in 2003. This is one of the problems. We don't know what's been granted, how much has been granted.
Madness.
You just don't know. It's all hearsay. So then I went back to the Magistrates Court and I asked them 3 questions. Now, I won't say the third one because I still haven't answered it yet, but they answered the first 2, right? And Sonia, I showed you all this communication, so you can verify it. And
all true.
So the 2 questions was, it says, because they had said liability orders, the crest and signatures from a Justice of the Peace. They said, are these your documents with the court crest on them? And are those signatures from someone in your court? And the Magistrates Court said to me they had nothing to do with us. They said the court crest was not authorised by them, which is actually a criminal offence, right, to use the Royal Coat of Arms without authorisation. And these signatures were not from anyone in the court. Now, they were squiggled, like they're totally illegible, but the squiggles were completely made up. They weren't from anyone in the court. So the councils, to justify what they were doing to this vulnerable person, had produced fake liability orders. And these fake liability orders are the ones that I've now submitted in this court case, pages 275 to 85 in the bundle, to show, look, not only the council's targeting vulnerable people, but they're creating fake paperwork to justify costs that they can't show have been incurred.
Oh my God. It's actually astonishing that they've done it, but they've done it on the basis that people don't check this kind of stuff.
Exactly. That's exactly it. People don't check it. And the issue is, Shona, this isn't just a case of this council who have proved doing fake documents. There's many other councils that are doing it. Not every council, but there's a lot of other councils using the fake documents. But the thing that was worse about this is a lot of the councils, the ones that are using fake documents, are just doing fake signatures. Whereas this council, they actually put a court crest on as well. So this council took it to another level. They weren't just using fake signatures. They actually put a fake court crest on it as well. And this is happening, like I say, across the country. This isn't just an isolated incident. I only managed to uncover it because I was helping a vulnerable person, and I could prove that the magistrate should have stopped it when I was there as a Mackenzie friend.
Right.
Allowed it to go ahead, and then I scuttled the enforcement agents, and so they sent in another enforcement agent, and I showed what the council were doing. So the magistrates had blood on their hands because they were causing it, so they had to be upfront, and they actually admitted these documents weren't theirs, which I wasn't expecting them to admit that.
It's absolutely mad what you found yourself caught in the middle of.
It really wasn't.
Yeah, but you're doing sterling work, but it brings me to my next point, and that is you're being told that what your case is not in the public interest. How could this possibly not be in the public interest. This is absolutely in the public interest. What the hell is going on there, Wayne?
Well, yeah, this is the major problem at the moment. So the judge who allowed the Ministry of Justice an opportunity to change their defence, which they haven't changed it yet. They've got to
without
tomorrow.
Application.
Yeah, without an application, without good reason. Yeah. So, I mean, you know, not paying a court fee, it's nothing to them because it's public money anyway, but it's still a requirement. But, you know, anyway, what he also said was he knows, right, on the merits they're going to lose because they can't prove any authority that these enforcement agents have, is going to have to address my documents of fraud at pages 275 to 85, and he has to address the fact that the council are using multiple enforcement agents when I've proven that they only have the power to delegate to one at a time, right? So on the merits, the fucked basically. Excuse my French, sorry. So he doesn't want to address the merits. So what he's done is he's trying to say, he said he doesn't see it's in the public interest to go to a trial, right? And if he doesn't go to a trial, he doesn't have to address the merits. Now, here's the problem. First of all, the Ministry of Justice in their defence said it has public interest. It said this case presents a valuable opportunity for people to understand their rights. So you've got the defendant itself saying there's public interest, and they want it to go to trial. They did do before I proved all this, yeah. So they've got the defendant saying there's public interest. You've got the High Court Enforcement Officers Association, who were invited by the Ministry of Justice originally, who declined the invitation but said this has public interest. I've got a report from one of the charities who have supported it, saying that there's public interest in this. Then you've got my case in 2023, where Judge Harrison said this is ripe for reform. And then what I've done is, because I've made an application just recently and I'm doing another one, I'm trying to show, apart from all these authorities saying there's public interest, that the public are interested. And I've had hundreds of letters from people supporting myself. Oh, you went a minute there, sorry.
Yeah.
You're back to you. Sorry, I don't know if that was my internet.
Don't worry, we're having a little bit of, but it's fine, absolutely fine. Yeah, go on, carry on. I think we're up to speed with you. Don't we love Wayne, says Public Notice. We do love Wayne because Wayne is drilling down on the stuff that they'd rather we wouldn't, which probably explains why there's a delay, and fairly outrageous that we're still the day before their defence is due, which they haven't applied for, has still not been submitted to you. And it feels like that you've caught them on the hop, really, Wayne. Just to so people understand what Robert said, what is this issue about? I don't know whether Robert has just joined us or not. But so Wayne, can you just kind of pressy it just briefly for Robert so that he can understand exactly what you're attempting to do at the CMC?
Right. So basically it's about the enforcement of council tax, right? Firstly is the bailiffs, they don't have authority to come into people's houses, and they're lying to people saying they have the authority. They're terrorizing people. This isn't a legitimate enforcement agent policy, because normally the only purpose of an enforcement agent is to come and make a distress against goods. The job isn't there to come and terrorize you and to scare you into payment. The job is to take your goods for the value. If you don't have any goods, then they don't bother you. But they don't take your goods. It's all an intimidation-based strategy to put fear in you to get you to pay. And they charge £310 every time they do this. Yeah. So it's a completely unlawful intimidation system just to terrorize people into payment. Yeah, and to pay their private fees. So that's the first one. The second one is the council are unlawfully delegating their powers, right? Which, again, I can prove in this one. So they're abusing their powers. And the third one is about the regulations themselves. The regulations are not compatible with the European Court of Human Rights. So they're the three issues in this case.
Right. So we need to get support for you, don't we? We need to get those letters. Some people have said that they've already submitted letters. Tell us what we need to do, Wayne. We'll do it.
Yeah, so if anyone's been affected by this, and I know there's thousands of people who have, I've already had hundreds of people already who have put letters in, but the more letters can help, the more that it shows the public interest, and that this judge is so perverse that it's completely ludicrous that he's going like this. And you've got to remember, the Ministry of Justice is responsible for HMCTS, and HMCTS administer all judges. So effectively, the defendant can appoint its own judge, which seems quite obvious in this case, the way things are going. So letters of support would be great. If you get, I've got a template, because one thing is, like, the way this judge is going at the moment is going to say, oh, voluminous emails. So I'm just trying to get one letter. Everybody reads the content and agrees with it. So you can read one letter, and then there's 100. So I can get that template letter. There's two ways to get it. You can either join my group on Facebook, which is Stop the Abuse, or you can send an email to bailiffprotection@protonmail.com.
And make sure, do me a favor, Wayne, when you finish this, email me both the link to your Facebook group and the second one that you're talking about, and I'll put them both in the description, so it will just be really easy for people to just go straight to. So at this moment in time, we're waiting to see what the Ministry of Justice are doing. Clearly you've caught them on the back foot. That's what's happened. You've caught them on the back foot, and they must, I would love to be a fly on the wall listening to what they have to say about you. I really would. Gwyneth said, I was shocked by the twists and inversions by lawyers in the courts. Yeah, well, that is the thing, is that that's what these people know how to do. And oftentimes it is my experience, Wayne, that if they can't win on the facts, they will attempt to win in all other ways, exactly by kind of knocking you out on whether it's, your procedure or the process. And as Markuson said, the process is the punishment. It is indeed. It is absolutely indeed.
Exactly.
Wayne, before you go, anything else that you want to add?
No, that's thank you. Just if anyone wants to follow the case, you can join us on Facebook and support the cause.
Wayne is a miracle man. You go for it. Well done, says Trip. Absolutely. A bit like C19. They just keep pressing ahead with it regardless. They do, Brett, but we've got a fighter here. Jackie says, thanks, Wayne. Keep fighting the good fight. You living legend indeed, everybody. This is the remarkable Wayne Layton. And there
Thank you for having me, Sonia.
Have a lovely, lovely evening. Take good care of yourself, Wayne. Absolutely wonderful. Magnificent. Magnificent.